Good morning, everyone. Welcome to our penultimate day of this year's unusual Crammer. A special word of welcome of those of you who are not able to join us earlier in the week. We look forward to spending the next hour or so with all of you. I've seen some familiar faces or familiar names rather. Unfortunately, I can't see your faces this morning, but familiar names on the schedule. And a very good morning and welcome to all of you. In recognition that business has naturally been extremely hard for many over the past months, please don't forget that we are showcasing videos of some unique, challenging and unusual stories on our website and at the end of each day. In this way, we hope that the storytellers and the audience can use the Crammer as a platform to learn from a variety of different experiences and hardship and ultimately support each other. These unusual stories will continue to be showcased after the Crammer and promoted through social media, so it's not too late to send one in. Please send it to marketing@adams.africa and we'll make sure it finds its way to the correct place. In today's session, we'll be looking at unusual opportunities, but before I introduce that topic and the speakers, we are going to get a wrap of what happened yesterday with Thando in his session that was entitled Unusual Circumstances. I apologize. Thando, over to you. Let's hear what you guys spoke about.
Thanks, Peter. Despite some initial technical difficulties that we experienced, I think we powered through, had a very good session. I would like to think that everyone that joined us gained a lot of insight. As you said, our discussion was on unusual circumstances, and our focus was more on how COVID-19 and the pandemic and all the measures introduced by it have affected legal obligations and perhaps highlighted some of the inadequacies of the legal obligations that were negotiated in the past. It kind of dovetails nicely with your discussion in the sense that any opportunities that you might have gained can be compromised by obligations that are not properly negotiated. So it was a very good session. Our first speaker was Vian Menkes, who focused primarily on force majeure and how the pandemic has affected the construction industry. Our second speaker, Gabriela, then touched on lease agreements and how the pandemic also affected lease agreements. And then we concluded with what is probably the most topical discussion right now, is insurance claims and the effect and the arguments that insurers are taking in relation to insurance claims and in the pandemic that we've seen globally, to be honest. We also concluded with our unusual stories. Mr. Shadrack Mtetra of Isobonelo, which is a construction company, discussed how they've been dealing with the pandemic and fighting their way through it. And we concluded with Mr. Terry Toron of TNT, who also gave insight on how they've been dealing with things and how they've managed to essentially grab some opportunities that have presented themselves this year. So all in all, it was a great discussion. Like you said earlier on, the videos and the unusual stories are all on our microsite, so please, everyone can log on, look at the videos. They're quite inspirational. And yeah, that's the wrap from yesterday. I hope everyone enjoys today's session. I'm going to also be following it. And good luck to all our speakers.
Thanks, Thando. Certainly some interesting discussions that took place, and as you said, please do go and view them on the microsite. View the videos by some of the businesses that we featured, and our presentations from each day are also available on YouTube if you missed out on any of it. Getting back to today's topic, it's an old saying that necessity is the mother of invention, and while some scientists would probably argue that curiosity is also a significant motivator, it has to be recognized that there are few times as fertile for the innovative part of the human spirit to thrive than in a time of crisis, both due to the spike in direct and in indirect needs. In terms of direct needs, the world's currently waiting with bated breath for the development of a coronavirus vaccine or other coronavirus therapy. the need for which has created new voltage in the field of pharmaceutical inventions. Direct needs are generally, I believe, easier to spot, but often they are of a more specialized nature, and therefore they're only available to a limited number of people in comparison to indirect needs. And I personally believe that while indirect needs are maybe more difficult to spot, it is in the indirect needs, or in respect of indirect needs, that the most potential for invention lies. If one measures this in terms of the availability of the opportunity to number of people. People may know, and I read this in The Economist recently, is that the invention of the bicycle is believed to have resulted from another global catastrophe in the 1800s, when the eruption of an Indonesian volcano caused widespread famine due to crop failure, resulting in people untimely and ultimately looking to other means of transport, seeing as they needed to rely on a greater variety of animals, including horses, as a source of food. This was tragic, naturally, but it presented the need for an alternative means of transport, which a man by the name of Carl von Drais, who devised the bicycle, albeit in a less sophisticated form than we know today. And so, of course, not only in the field of technological invention that opportunities exist, but also in the business environment, and shall we not forget also in personal development. I believe we've all needed to look inwardly quite significantly over the past few months. But we shall today leave the psychological toll of the pandemic unattended and focus instead on the spheres of technology and business. This is the context of our discussion today, which, as I've mentioned, is themed Unusual Opportunities. And it looks at opportunities brought about by the pandemic from three perspectives. The first is direct needs, with reference to the development of vaccines and therapies. The second is the advancement of the need for existing technologies, specifically with reference to 3D printing. And thirdly, we're looking at business survival in the face of what many would see as certain closure, with reference to business rescue. First up this morning is Portia Manzini, who's an associate at our firm, and she will be discussing with expert advocate Johan Smit how the timeous utilization of business rescue proceedings may come to the aid of businesses who face the potential for financial distress in whichever circumstances. Portia, over to you. We look forward to listening.
Good morning, Johan. Good morning, everyone. Today I'm sitting with Advocate Johan Smith, who is an advocate at the Johannesburg Bar, an experienced insolvency advocate. He's been involved in many of insolvencies around the country, and as an interest, might just add that he is actually he's representing one of the parties in the business rescue of SAA. In our discussion today, we'll be talking about the business rescue and how it has assisted companies. Many companies were adversely affected this year by the pandemic, the COVID-19 pandemic, which started late last year. For South African businesses, this effect were worsened by the national lockdown, as it required non-essential services to close down for a minimum of 21 days before the restrictions were lessened. During this period, very few businesses were able to generate income. As a result, we saw a number increasing in businesses filing for business rescue. Here with me, Johan is going to explain the concept of business rescue and what it entails.
Thank you, Portia. Business rescue is aimed to provide financially distressed companies with a breathing space to restructure their affairs, to keep on trading, and to rescue as many jobs as possible. That is achieved through a moratorium provided by the legislation.
Thank you, Johan. You've mentioned something very interesting there. You've said that the business rescue is a mechanism that provides companies that are financially distressed with a moratorium. What does financially distressed mean for the ordinary South African?
Also, simply put, it means that the company is reasonably unlikely to pay its debts falling due and becoming payable for the next 6 months.
I take it from that angle then that, there is an obligation on directors to assess their companies for internal and external threats that might affect their liquidity and solvency position. Since the effects of the COVID-19 pandemic were not timely predicted and the effect thereof grew exponentially, it is difficult for me to see how companies could have foresaw this and prepared for it timely. I mean, we're looking at a 6-month projection here. If we're thinking of when the COVID-19 hit our shores in March, and the 6 months going back would have been sometime late last year. But many companies during this period had already paid out bonuses to their companies, executive and employees. How does business rescue assist those companies?
Mainly, Portia, through the moratorium, which prevents creditors from instituting legal proceedings without the leave of the court or without the consent of the practitioner.
Okay, I like that. So the moratorium basically is like a shield to the company. It prevents creditors from instituting legal action against the company while it is in business rescue. And it also allows the company breathing space to restructure itself without being drawn into litigation, which we know can be lengthy and expensive. What are some of the key factors that a company in business rescue that now has a protection under the moratorium, what does it need now to do in order to successfully move out of the business rescue?
Portia, as far as I'm concerned, there are 2 key factors. The first is that there is post-commencement finance. Post-commencement finance is necessary to pay necessary expenses for the company to continue doing business, paying salaries, for instance. And the second important factor is the appointment of an experienced and trustworthy business rescue practitioner who is trusted by employees, by the company, and by creditors.
Okay, so I like that idea. Yeah. If we have a practitioner who is trusted by creditors, assisting with the development of a plan, already there we can see that the plan is most likely to succeed. In your experience, what does this plan normally have? What goes into the plan?
Well, Portia, it is necessary for creditors to buy into the concept of business rescue, and more particularly, the plan developed by the business rescue practitioner. The business rescue practitioner would develop that plan in conjunction with the affected persons, which would include the creditors and employees. Ordinarily, creditors would look at what would be the best result in the circumstances, bearing in mind that the legislation provides for a balancing of everybody's rights.
And with the employees there's also, I suppose, they also go in as affected persons. They're catered for under the plan.
Yes. One of the main aims of the legislation is to protect and create jobs as far as possible.
Okay. With what has been happening the past 6 months here in South Africa, we've seen employers and companies cutting jobs for employees. Some employees are taking salary cuts. Is this something that is also catered for in the plan, the renegotiation of contracts?
Yes. So restructuring of affairs is one of the key elements of business rescue. A business rescue practitioner can also, in terms of the legislation, suspend certain contractual obligations, and negotiating with employees is one of them.
Okay, so I suppose business rescue does help in companies that are that have appointed an experienced practitioner, where the employees are willing to take cuts in their salaries. And if this business rescue has been implemented for a period of, for example, 6 to 10 months, but the creditors are not seeing any gain to it, neither are the employees, how would one know if that business rescue is being successful?
Portia, there is a second goal to business rescue, and that is a better return to creditors, meaning that creditors would receive a better return from the business rescue proceedings than they would from the immediate liquidation. That would be the benefit.
Okay, this is excellent news. I love it. So if we have a company and we see that it's not doing as well as we thought it would in business rescue, in the sense that it's not trading on a solvent basis, there is a secondary goal that creditors are at least receiving more through this business rescue proceeding than they would have in a liquidation.
Yes, and that is recognized.
Wonderful. Thank you so much, Johan. I really appreciate having you here. The take to our clients out there and directors is to begin with business rescue proceeding as soon as you see that your company is not trading or will potentially be trading on an insolvent basis in the next ensuing 6 months. So do not wait. Immediately approach attorneys and your creditors, as these are people who will provide the post-commencement funding, which Johan alluded to earlier on, and loans to assist with the business rescue proceeding. Thank you very much.
Thank you, Portia.
Thank you. Are there specific objective conditions that must exist before a company can subject itself to business rescue? Yes. The biggest one would obviously be the financial status of a company. If from the financial statements, it is clear that the company is not only commercially insolvent, and by this I mean it has the liabilities exceed its assets, but it is able to meet its day-to-day financial obligations, then in addition to this, it is also factually insolvent, where it is unable to meet its day-to-day financial obligations. Then that is an objective ground on which a company can place itself in business rescue. And then the other one, which a creditor would see, is when a company is asking to defer payment obligations. So that if you as a creditor are now being asked by a certain data company to defer payment terms or to negotiate how the debt is going to be paid, then that would be a ground for you to consider perhaps putting the company in business rescue. And the same goes for employees as well. If the companies are asking them for to pay half of their salaries this month, in the hope that in the following months they will be paid back, then that is a ground for concern, which can be objectively determined by the employees. And in addition to that, trade unions are also able to request financial statements from companies in order to consider pursuing business rescue proceedings against the company.
Thanks, Portia. Thanks for a informative talk. Another question that's come through is whether or what the rights of a creditor are against the commencement of business rescue. Can creditors actually slow down this process? I imagine creditors should actually not want to slow it down because they would probably get a better return, as Johan alluded to. But are there mechanisms for them to slow it down?
There are mechanisms. Number one, it would be to ask that the court uplift the moratorium that Johan and I spoke about earlier in respect of that claim. So what that entails is that the company has, the creditor has to approach the High Court to make this application, or can ask the business rescue practitioner to consent to the upliftment of the moratorium. However, since business rescue proceedings are there to protect the companies, they have to be very solid grounds, if I may put it like that, on which this creditor would be asking for the upliftment of the moratorium. It's not something that our courts are likely to grant, but they have done it in some instances. Good grounds have to be shown though for that.
Yeah, I can imagine that it's not something the court would do lightly. Another question, Portia, that's come through is who forms part of the business rescue team? And I see many questions are from the perspective of creditors. Would a creditor be represented or have a representative on the team that is part of that's attending to the business rescue, or does this process run completely independently of creditors?
This process runs with the creditors. The creditors are part of the affected persons that must not only just be consulted when the practitioner is preparing a plan, but they also get to vote for the plan. If they are not voting for the plan, then the practitioner has to go back and prepare an amended plan. So they are part and parcel of the proceedings together with the employees. And yes, they can have representatives in the form of attorneys or a member of one of them collectively. And the same happens with employees. They also affected persons as well as the shareholders of the company. You would understand that in most instances, the shareholders are sometimes also the directors. However, there are instances where companies have different directors and shareholders, and they are all part of the affected persons that are part of the process of business rescue.
So they are recognized. It's not as though they have to sit on the sidelines.
No,
final question that I think we can address, Portia, is it's an interesting one that came through. Is does insolvency and business rescue apply to non-profit organizations, or does this not apply to non-profit organizations?
The Companies Act applies to all companies. So the NPOs are also part of that, although their aim is not to make profit per se, but if they are defaulting on their obligations, then yes, they can be. You can apply for business rescue for them.
I apologize, I was on mute. I'm going to conclude the questions at this point. Thank you very much for a very informative talk. We appreciate it. I definitely learned something. I always thought that business rescue was the beginning of the end of a business, and I think it's important to take away from your discussion is that it needs not be the beginning of the end if it's implemented harmoniously and it's used correctly and implemented by the correct people, then it could actually be what it's supposed to be, which is business rescue as opposed to the winding down of a business. Portia, thank you very much, and good luck at court. I don't know if anyone would like to know where Portia is, but she is actually at court this morning. So we're wondering what her environment is like there. Portia, thank you very much for an informative talk.
Thank you so much for having me. If there are any questions that I haven't been able to get to, I'll get back to our clients via email. Thank you very much.
Hello, everybody.
Thanks, Portia. Yes, I think it's worth emphasizing that, as Portia mentioned, we'll be addressing all questions that we've not been able to address in the question and answer sessions. We will address separately to make sure that everybody's questions have been answered. We're moving on to our next speaker now, who is Tapelo Montong. He's a senior associate and a patent attorney with our firm. Tapelo will be addressing us on how a revolutionary, relatively new technology, such as 3D printing, has found sudden relevance in time of crisis, and also which intellectual property considerations one should bear in mind when confronted with this new technology of 3D printing. Tapelo, over to you.
Hello, everybody. Thank you for joining my talk on the need for speed in 3D printing to combat the novel coronavirus. Well, as you may know, 3D printing, which is also referred to as additive manufacturing, involves using a CAD file to successfully print layers of a desired material, thus forming a 3D printed product. In a nutshell, that basically means that one needs to have some form of a digital twin of a product or a CAD file that relates to that product, use that CAD file with a printer, 3D printer, to produce the desired product. Now, you'll notice that over the past 15 years alone, we have seen the proliferation of 3D printing in various industries. The slide on the screen shows the extent at which 3D printing has grown and the various types of items which have been generated by using additive manufacturing. Fast forward to the year 2019, 2020, we have seen how many companies and individuals have used 3D printing to manufacture medical equipment, such as ventilators, face masks, nasal swabs, etc., just for use in combating the novel coronavirus. You'll also notice on the screen that the number of patent applications which have been filed in the past, especially from 2012 until 2019, has increased quite substantially, and we expect this number to also increase quite substantially since the start of the pandemic. Whilst 3D printing appears to be the new buzzword and the best mode of manufacturing components in the untraditional sense, it does, however, have its own problems, particularly when it relates to matters of patent infringement. For those that do not understand patent infringement, at a very high level, in general, whenever a patented item is 3D printed without the authorization of the owner of the patent, the act of printing or manufacturing that patented item by using a 3D printer can constitute an act of infringement of the patent. Now, the first issue that is of concern, mostly to patent holders or future patent holders or current patent holders, is the decentralized nature of 3D printers, which in a nutshell enables the end user to be the manufacturer and or consumer, and in some instances, the seller of the product. This decentralized nature of 3D printing thereby lowers the barrier of entry to market of patented items illegally manufactured by 3D printers. And normally, by mere effect of using this decentralized nature of 3D printers, people would struggle, or rather patent holders would struggle to identify infringers or identify certain acts of infringement. Secondly, the other issue of concern is the ease at which CAD files can be shared amongst 3D printer owners. As you may recall, I indicated earlier on that one needs a CAD file or a digital twin of a product in order to manufacture that product by using a 3D printer. So by mere fact that these files can be shared easily amongst 3D printer owners indicates that it's a huge risk for most patent holders who have rights that are associated with a particular patented item that can be infringed easily by people who just can share files all over the show without having any regard for patent rights. Now, what most people have done is they started encrypting their CAD files just to make sure that once encrypted, one would need a particular code to open that CAD file. However, that is great. However, there are issues associated with that as well. And one of the issues is that with 3D printing, one can necessarily take a product and scan that product to produce the CAD file. And once you scan that product and produce the CAD file, whether that CAD file, the original CAD file, was encrypted or not, it really would not matter because that person would have a digital version of that CAD file. Also, the other thing is that once a person also has an actual product, the patented item, that actual product can be drawn from scratch into creating a CAD file that one would be able to use as a digital twin of that product and use it to create the digital twin of that product. Now, with these problems in mind, it can appear that 3D printing can undermine patent rights. However, it will come as a relief for current and future patent holders to know that there are several courses of action or IP strategies which can still be used to prevent the unauthorized use of 3D printing from undermining the IP system. For example, theoretically speaking, patent holders can hold owners of 3D printers liable for direct infringement of the patent in the event that the 3D printer owner is caught manufacturing that patented item. However, with the mass expansion of 3D printers and massive owners of 3D printers, it may admittedly be difficult to keep track of each and every owner of a 3D printer and the items manufactured by their 3D printers. So what do we do? So from a patent strategy, I'll just tackle this from a patent strategy. From a patent strategy alone, one can, in an attempt to thwart or prevent people from illegally disseminating these digital files or CAT files, one can perhaps opt for using a specific language in a patent application that is filed. And that particular language would be in the form of what we call Pcr claims. So these Pcr claims are typical software-related claims, and they would read as follows: that you have a computer-readable medium that stores instructions, which when executed by a processor are configured to cause a 3D printer to print out that particular product. We believe that the use of those types of claims, the Pcr claims, would necessarily prevent or help prevent the dissemination of files. Because if someone, let's say, has this computer readable medium that stores those instructions, and you find that someone has those particular that particular computer readable medium that is used to generate or print out your patented item, then I suppose that you'll be able to have some form of legal recourse and take that person to court for infringing that particular claim that is in the patent. The other thing that is that can be used to prevent the dissemination of these CAT files would be using an anti-scanning material on your actual patented product. Now, this anti-scanning material would necessarily prevent people from scanning your actual product and from scanning that actual product, generating the digital twin of that product. Another recourse or course of action would be what we call indirect infringement. So in general, for one to succeed with an action of indirect infringement, the patent holder must show that one person who had knowledge of the existence of the patent must have shared the digital twin of the patented product and caused another person to create that patented product. As indicated, proving indirect infringement may be difficult. This course of action may come in handy from time to time. However, I believe that we can rely on that course of action right at the end if all else fails. Obviously, these courses of actions or IP strategies that I've just mentioned are but some of the many courses of actions that can be used and are readily available for current and future patent holders. Now, in conclusion, before I end my presentation, just wanted to highlight that the use of 3D printing as evidenced during the pandemic is certainly on the rise, and we expect to see various IP laws develop quite substantially in this area in the next couple of years. It may appear unusual, at least in the traditional sense, to have an IP strategy that is arranged to not only protect the invention, but also cover the digital version of the preferred embodiment of that invention. However, as the pandemic has shown us in the past couple of months, it's never too late to adapt to new norms, and in this case, to the use of robust IP strategies to combat 3D printing IP-related issues. Thank you.
Thank you, everyone.
Thanks, Tapelo. Thanks for a very interesting talk. 3D printing is indeed, it's amazing to me how 3D printing is already being predicted as a technology that we would each have a 3D printer in our house. I mean, it's in contrast to predictions of the past, for example, that we were made in relation to the personal computer, that everybody said, well, no one will really need it. The predictions now, knowing how quickly technology develops at this stage, are that we will each at one day, some stage, we will have a 3D printer in our houses, and I believe that's as you've mentioned, that decentralized nature of 3D printing that we are expecting to realize is what is going to create challenge for IP owners. Is that there's no big factory that you can go and stop and sue for damages. You have to look at people's houses, and each house will essentially be a factory. And that is indeed a very difficult position to be in, I believe, for intellectual property owners or for creators. Against that background, I mean, the enforcement difficulties that you've discussed, would you discourage people from pursuing patent protection for inventions that are 3D printable?
Thanks for that, Peter. On the contrary, I would certainly advise inventors to still consider obtaining some form of patent protection for their 3D printable items, or even items which are not 3D printable. And the reason for that is, as I've mentioned, that it may be difficult for one to police 3D printer owners and what items that they're printing out. However, history has shown that a lot of companies have started using 3D printers to manufacture intricate components or any other form of components on an industrial scale. So if one were to file a patent application that is related to an item, whether it's 3D printable, and they use a robust IP strategy which involves covering the digital version of that patented item, and if they were to find that there's a company out there in the world or wherever they may have filed a patent that that company is using 3D printing technology, and that 3D printing technology actually is used to produce that patented item, then they can certainly enforce their IP rights. So it may be difficult right now, or maybe a bit confusing perhaps, especially for patent right holders, in regards to the issues that are associated with individuals printing out items in their own homes for their personal use. However, policing that may be difficult. However, if you look at enforcing your rights on an industrial scale against big companies, then I would certainly advise inventors to consider obtaining some form of patent protection still.
Yeah, indeed. I think listening to what you're saying, an additional consideration, I believe, is that patenting or any kind of intellectual property protection is, of course, not only obtained to be able to enforce. You also pursue intellectual property protection in order to let's say, capture your intellectual property assets in a more tangible form, a form in which you can identify and characterize them, and to provide basis for you to license someone to manufacture on your behalf. And I therefore believe that one shouldn't necessarily stare yourself blind against the potential difficulties for enforcement when considering IP protection. And something else that occurred to me was that you can, I think we should expect to see some technology development around the protection of 3D printable articles. I mean, and this is now just off the top of my head. Maybe it's irrelevant or unrealistic, but to address the specific difficulty of scanning an article to create a CAD file, maybe there's some other technology that someone can develop that would make an article unscannable. Whether that's possible or not, I don't know. But maybe we'll see some technology development around that, which would allow people to protect their rights more effectively. Tapela, our time is unfortunately expired. There are some additional questions that came through, particularly in relation to the application of copyright, and I do believe we should give some attention to that, because copyright, I think, is going to be specifically relevant in the protection of authors or creators of articles or products that can be 3D printed, and in the protection of the files, CAD files. Those are primarily relevant to copyright, but I think those questions we'll address by email, and maybe we should do a separate segment on that we can post to the microsite, because that is definitely something that needs particular attention.
Absolutely.
But Sapela, thanks for your time. Sorry that we can't hear more from you, but I'm being told we need to move on. So, thanks a lot.
Thank you, everyone. Cheers.
Our final speaker of this morning is another one of our senior associates. She's also a patent attorney with us, Dr. Charlene Narayan. Charlene's topic falls within her area of expertise, and I believe is particularly interesting in that it deals with the topic that we've all become overnight experts in, being the development of COVID-19 vaccines and therapies. We've read a lot about it in the media, and I think we all believe we know a lot about it. But I hope Charlene will dispel any fake news that we might have read. And in this regard, the contribution of one of her guests this morning, Dr. Yvonne Holt, is going to be invaluable. Dr. Holt is the Chief Medical Officer at Next Biosciences, who has indeed been significantly involved in combating the virus at a direct opportunity level. Charlene and Dr. Holt, we look forward to hearing from you. Over to you.
The coronavirus that causes COVID-19 has infected 33.5 million people worldwide, with over 670,000 cases and almost 17,000 deaths in South Africa. Admittedly, yes, South Africa has shown a highly positive recovery rate of 90%, and we feel we have beaten the virus. The global impact of this novel virus has nevertheless been severe, with some European countries now experiencing a second wave of infection. Patients that develop serious symptoms and recovered from virus infections are often left with long-lasting complications. Accurate testing remains important in controlling the virus and reducing its transmission. Currently, the Pcr Diagnostic Test is the best method to test for COVID-19 infection, which is a test used at Next Biosciences.
Dr. Holt, can you tell us about the COVID-19 testing being conducted at Next Biosciences?
Yes, sure, Charlene. We do diagnostic PCR testing by Thermo Fisher. PCR stands for polymerase chain reaction, and it tests for the presence of RNA of a virus. RNA is very similar to DNA, which we all know about. So a swab is taken from the back of the nose or the throat. In the lab, we swirl this swab in a bit of liquid, which releases all the cellular material collected on the swab. Then we extract the RNA from this liquid, test the RNA to see if the viral RNA is present. We test for 3 different RNA genes to know if the COVID virus is present in this certain patient.
Under South African patent laws, as in many other countries, a method of diagnosis practiced on the human or animal body cannot be patented. A diagnostic method and test is patentable where the diagnosis is actually performed on a sample and not directly on the body. In order to be patentable, the invention must be novel or new, and inventive or not obvious. While the PCR diagnostic test used by Next Biosciences is based on a well-known method, the test needed to include other new key features in order for valid patents to be granted.
Dr. Holt, is the diagnostic test used at Next Biosciences a patented technology?
The test is a patented technology by Thermo Fisher. Their scientists developed this PCR test to test specifically for coronavirus. The test, as I said, tests for 3 specific genes on the coronavirus. Other companies around the world have developed their own patented tests too. Although all the tests are the PCR technology, each test varies in the balance of chemistry that is used, the genes that they test for, and the sensitivity and specificity. Therefore, each of these companies will market their own IP, their own methods to the scientific laboratories for the lab to choose which is the preferable test for them.
If you are aware, SAHPRA has approved a rapid point-of-care serology test for COVID-19 antibodies and 3 lab-based serology tests. What is the difference between your PCR diagnostic test and these serology antibody tests?
Well, that's a very important question and something that everyone really should understand before opting to do either test. The PCR test is a diagnostic test. So that will tell you if you have the virus at that point in time. It detects the presence of the virus in the body. Your serology or antibody test basically tests if your body has produced antibodies to the virus. Now, how this works is when a human being is infected by a virus, our immune system produces antibodies to fight that virus. Initially, we produce IgM antibodies, so that's early on in the infection, 2 to 3 days after infection, and these are pretty non-specific antibodies. They are just there to identify the virus. Then the immune system makes IgG antibodies that are very specific antibodies, and they go out to try and eradicate the virus from the body. Some people, it has been shown, develop antibodies, others do not. There's still a lot that we don't know how our immune system reacts to infection by coronavirus. So it is important to understand that just because you have not built up antibodies doesn't mean that you haven't had the virus. Antibodies may not last for very long. So they may only last in our bodies for about 3 months. Thereafter, the body stops producing them. The reasons for having an antibody test is really more for epidemiological studies, for us to see who's been infected, if they have antibodies, and who we should vaccinate. Otherwise, it doesn't necessarily give you a diagnostic result to say that you definitely have the infection.
A COVID-19 patient may or may not present symptoms that require treatment. The symptoms have been of a wide range, with patients with particular comorbidities and elderly patients presenting the most severe symptoms. Scientists are racing to develop vaccines and drug treatments. In light of the urgency of the pandemic, the first approach has been to try drugs that have already been approved for other conditions. This is known as drug repurposing. Finding new uses for known drugs is vital to accelerating the development of treatments, as it speeds up the time it takes to make a treatment available. This is mainly because researchers don't have to repeat the earlier stages of development to show drug safety. A new use of a known drug can be patented if it is novel and inventive. We have heard a lot about remdesivir. This drug was originally developed to treat Ebola. It was shown to shorten the recovery time for patients hospitalized with COVID-19. Cipla and other pharmaceutical companies have obtained authorization from SAHPRA to import the generic of remdesivir under a Section 21 exemption. This allows for the import of medicines that have not been scrutinized by SAHPRA, but which have been approved by regulators in other countries. However, in August, the National Department of Health issued treatment guidelines where it decided to not recommend the use of remdesivir due to its high cost and marginal benefit. It has instead only been recommended for clinical trials. Oxford University is running a recovery trial to test whether existing drugs could be useful in treating COVID-19. It found that the drug dexamethasone reduced mortality among ventilated patients. Dexamethasone is a steroid that has been used since the 1960s to reduce inflammation in a range of conditions. The original drug is no longer under patent protection, but there are existing patents for related inventions. Dexamethasone has been in use in South African hospitals to treat critically ill COVID-19 patients since June, where it has reduced fatalities of patients in ICU by 25%. A key objective in fighting the pandemic is to develop an effective vaccine that protects people from contracting COVID-19 before they are exposed to the virus. There are more than 160 projects globally that are focused on developing such a vaccine. While the vaccine is only expected in mid-2021, this is exceptionally fast for vaccine development, which typically takes 10 to 15 years. Russia has already approved a COVID-19 vaccine, but there are concerns about its safety and efficacy. South Africa is hosting local legs of 3 international COVID-19 vaccine trials from Oxford University, Novavax, and Johnson & Johnson. Oxford's vaccine candidate has been shown to trigger a strong immune response. The trials have resumed after being put on hold due to a trial participant in the United Kingdom having an adverse reaction to the vaccine. The Novavax vaccine candidate is engineered from the genetic sequence of the virus that causes COVID-19. Studies show that it protects against COVID-19 infection in nasal passages and against lung disease. The trial in South Africa will evaluate efficacy, safety, and immunogenicity. The Johnson & Johnson vaccine candidate uses the common cold virus to deliver the COVID-19 protein into host cells, where it stimulates the body to raise immune responses against the virus. Research shows that a single dose of this vaccine protects against the virus. The South African trials will assess the safety and efficacy of the vaccine. Researchers succeeded in identifying the structures of the key proteins of the new coronavirus. This would normally have taken months or years to accomplish, but through open collaboration between researchers, it was completed in weeks. Open global cooperation is imperative at this time to arrive at a successful vaccine in an accelerated timeframe. Now that international travel has been reopened and many restrictions have been lifted, we cannot become complacent. Until the wide global spread of the virus has been contained, we still need to rely on key measures such as social distancing, frequent hand washing, and monitoring flu-like symptoms. Take care and be safe.
Thanks very much, Charlene and Dr. Holt. Indeed, a very topical discussion and one that I'm sure the audience found very interesting. We've got some questions that came through, and Dr. Holt, I think the one that I want to ask you've already answered essentially. It's about whether there's a test that detects the presence of a live or active virus. I think maybe if you could just emphasize again the difference between the PCR test and the diagnostic test that you, or the other test that you referred to.
Yes, so the PCR test is the test that will detect the live or active virus in your body at that time. The antibody test tests your antibodies or the reaction of your body to a past infection. So the PCR test is the one that will test if you have the virus on board.
Thanks, Dr. Holt. Charlene, you mentioned it toward the end, and also dealt with it in some of your comments, that we're seeing a lot of cross-border collaboration throughout the world to combat this virus, and I think that's one of the reasons why we're seeing such speed in the development of the therapies and vaccines. Getting back to intellectual property, do you think that obviates the relevance of patent protection, or what is your impression of the place of patent protection in cross-border global cooperation?
Thanks, Peter. No, not at all. Pursuing patent protection is not an act that would obviate cooperation, and the two are not mutually exclusive. The existing treatments that researchers are currently investigating, for example, the pool of over 160 vaccines, these were developed because of the protection that patents afforded them. So this resulted in this large pool of technologies that we now have available to test for a COVID-19 treatment. So no, I would not discourage the pursuit of patent protection. In fact, it has stimulated the development of treatments.
Indeed. Dr. Holt, I think the topic that's on everybody's mind at the moment is this concept of a second wave that we're going to be facing. Do you have personal views on whether or not we are going to experience such a wave and how it might present itself in South Africa? I think that it'll be interesting to hear your thoughts on that.
Yeah, so watching the daily test numbers and positive cases, we have plateaued. Every now and then there is a spike in a region. Recently, in fact, last week, there was a spike in Cape Town, again amongst students mostly, because they've started socializing, going to clubs and bars and things. So there was a spike. But they've all been sent home and things have calmed down. So I think we will be seeing spikes here and there. I think we are very well protected now. You know, we're going into our summer season. Corona doesn't like warm weather. So I think that is on our side. People must still be very conscious in public transport to wear masks, wash our hands after we've come from the shops, minimize our social gatherings. Yeah, as we've seen, the minute there's a big party, too many people together, too much contact, we get spikes. So I think, and Corona is going to be with us for another year at least. We have to learn to live with it. We have to learn to protect ourselves and keep it at a minimum.
I think it's valuable to hear it again and again that we're going to. Everybody talks about the end of this. When we see the end of this next year, February, and to appreciate that this is not something that there's going to be a line in the sand and that'll be the end of it. It's going to take some time. And unfortunately, we live in the time of immediate gratification. So I think this is an important reset for society, actually. That we realize that certain things we cannot have immediately. There's certain things we have to take time with, and certain things take time before we get to a point where we've built up natural antibodies to this new virus, and it's something we simply have to wait out. Technology will be to our aid, but unfortunately we can only go as fast as nature allows us in certain respects. Charlene, Dr. Holt, thank you very much for your input and your talk this morning. I think it's one that the audience definitely enjoyed. And Dr. Holt, thank you for your time as well for this morning for joining us. We appreciate that. We've got a separate question on whether the slides of the presentations will be available. I confirm that those are available on the microsite. Please go to www.adams.africa/Crammer. All of the talks will be presented and will be available there. That brings us to the end of this morning's presentations. I hope you found them informative, and I'll make some concluding comments at the end. But as I mentioned earlier in the introduction to this session, we all know that business has been extremely hard for many during this time. And to try and do our part in one respect, we are showcasing videos of unique, challenging, or unusual stories on our website, and then at the end of each day's presentations. And we hope that in this way, the storytellers and the audience can use the platform to learn from a variety of different experiences and hardship, and ultimately support each other. If you have any unusual stories that you'd like to send us, please make a short video, engage with any of the speakers or anyone you might know at Adams & Adams. Send it through to us. We're happy to promote it on our social media platforms. It's not late to do so. Please send it to marketing@adams.africa. The two featured businesses that we are looking at today are Regionise and Gareth Devine Biokineticists. The first up is Recycling Initiative Regionize, which will be introduced to us by its two co-founders, who will tell us about how they used the lockdown to focus on other aspects of their business that they found particularly valuable. We look forward to hearing from them.
Hi, I'm Chad Robertson, and I'm Cousin Community. We are the co-founders of Regionize. Regionize is a recycling solution on a mission to provide recycling services to all South African households. But importantly, we do so inclusively by working with informal collectors and integrating them into our system. We also reward households with our virtual currency called Remani, where they can earn data, airtime, or grocery vouchers when they recycle with us.
2020 has been a difficult year for all of us. Negatively, we have had to stunt our expansion and growth. But from a positive standpoint, we've had an opportunity to work on our brand as well as grow our team. And thanks to Adams and Adams' help, we've been able to trademark Regionize and are in the process of finally beginning the beginning steps of expanding our operation.
Thank you.
Interesting times. Our second feature business this morning is Gareth Divine Biokineticists, and they will be chatting to us and showing us how innovatively they took their business online during the lockdown. We look forward to listening.
Hi, come in.
Good, and repeat it. 11 more of those, please.
Okay, so when you eat, let's go. Forward lunge. Together and
Thanks, everybody. That brings us to the close of our presentations today. I see we are 2 minutes over schedule. We seem to have slotted it in quite nicely this morning. Thank you for joining us. We hope that we will see you again at a live Crammer event in person in future. Although I believe that doing it in this particular manner, we would appreciate your feedback on how you experienced it. I experience online events. I get various snippets of feedback from people about how they found more time for themselves, more time for their families, and then others who feel that they miss the socializing aspect of being at an office, of seeing people in person. To that effect, you'll be getting a feedback letter later today. Please do take the time to complete it. I believe it'll only take a few minutes of your day, and it will certainly be of significant value to us. Thank you to our speakers this morning, Portia, who told us about business rescue and about how business rescue is not the beginning of the end, but hopefully the continuance of a business. If a business is in distress, businesses find themselves in distress, and there are legal mechanisms to move them out of that distressed position. Tapelo Montang chatted to us about 3D printing and the intellectual property considerations around those, and personally I look forward to having a 3D printer in my house, but also as an IP attorney, I hope we're able to iron out the challenges that we face from an enforcement perspective. And then finally, a few moments ago, we listened to Charlene, Rupp, Narayan, and Dr. Yvonne Holt telling us about COVID and maybe dispelling some of our fears and giving us a dose of reality as well as to what we can expect the future to hold. We hope you enjoyed our talks and that you'll have a productive day further. Please join us tomorrow for the concluding session of our Crammer. Thank you for joining us today and earlier in the week. We appreciate your support, and we hope that you'll also go out and support the businesses who we've been showcasing. Please do visit their websites, engage with them, and yes, have a good day, and we'll see you all again tomorrow. Goodbye.